common law trademark. This is something we touched upon for copyright. It's the same thing here. So as soon as you use it, you have a common law trademark. It's not federally registered. So the difference here is that immediately upon use, the federal one, upon issuance of a certificate, is when it's effective. For common law, it's a limited geographic reach. It's California only. Every state has its own patchwork of state trademark laws. Whereas for federal, you have a nationwide scope. So that's a lot more reach right there. In state court, if you want to sue someone for infringement, you're stuck in state court. If you have a common law trademark, you're filing in San Diego Superior Court, where the judges don't have a ton of resources. And the judges aren't super conversant on intellectual property law because it's really not a state issue, it's a federal issue. Whereas if you have a federal registration, you have exclusive access to the federal courts, meaning if you have a federal registration, you can only sue in federal court. You can't sue in state court. The judges have a lot more resources and they're much more conversant on trademark law. For common law trademarks, your damage scope is really limited, whereas for federally registered, you get statutory damages and you can get attorney's fees if you can prove willful infringement. So your remedies are much more robust. For common law trademarks, you identify them with that little TM, whereas for federally registered, it's circle R. So the first person using that mark in commerce in that classification gets the trademark. I just responded to a cease and desist. A client of mine got hit with a cease and desist letter. These lawyers are writing harassing letters saying, stop using this mark. And so I did a letter pushing back saying, actually my client was using this mark 2 years before your registration. So how about we just coexist? And should you guys sue us, we are going to countersue for declaratory relief to invalidate your trademark because we were using it first. And I haven't heard back from them. The TM is really just a way of telling people, I'm claiming this. I'm putting my flag down right here. This is mine, don't use it. That's what the TM is. It's really it's a symbol to everyone else, at least in your classification for whatever your business is. So if I'm making baseball bats, then we're in totally different classifications. But you don't need the TM to enforce a common law trademark. Okay, some other benefits of registering. You get to enhance your brand. You get more marketplace prestige. If you have the circle R next to your name, it enhances the value of your brand. Shows people that you're more established and you're more professional and you're really invested in this. It also protects your investment in your marketing because if someone's going to go infringe, now you've got the force of a federal registration behind you. So if you're going to invest in marketing this brand, you protect it at the front end by getting that registration. It also enhances the sale value. Now this is a little bit subjective, but I've spoken with people who are thinking about selling their business and I tell them, okay, have you trademarked your name? No. Okay, well, what actually are you selling them? You're selling them your common law rights. If you have a federal registration that you actually have something tangible to assign, I think, in my personal humble opinion, it enhances the value of your business as you're trying to sell. Also, you get a presumption of validity. So if you have a common law registration, you have to prove in your case in chief that you're the first one using it in commerce, that this is a distinctive name. You have the burden of proof on you. Whereas if you have the registration, that presumption is in your favor. The other side has to overcome the presumption. You're in a position of strength in litigation. The judge will assume your trademark is valid. The other side has to disprove that. So you're in a stronger footing.